Thank you so much to Karen, to the National Constitution Center, and to ADL for putting on this program that I think I can speak for at least those of us who've been doing it for a long time, has come to occupy such a special place in our hearts. And for the folks who are just here for the first time, I guarantee you this is the best time you're ever going to have, certainly this term. So thank you to new panelists and old. I just want to make two brief precatory points. One is that we have an immense amount to cover, and so we are going to go briskly. And as folks who've done this event before know, it's tough enough when you have 4 or 5 big cases, but when you have 12 big cases in a term, it's really a challenging. So we're going to go as fast as we possibly can and be as thorough as we can, but I am going to beg you to do as Karen just said and pop any questions you have into the Q&A, and we will try to get to them as fast as we can and as many as we can. And my other just note for you is that my role today is as neutral moderator. I've certainly written and talked about a lot of these cases, but in the interest of moving things along and keeping it running on time, I will serve today in as neutral a function as I possibly can. That said, we're going to start with everybody's favorite part of the year, which is the big term overview. What happened? Erwin always does that standing on one leg. Erwin, take about 5 minutes to try to walk us through the big themes and trends of the year.
Thank you. It's an enormous honor and pleasure to be part of this program. I've been part of all of them from ADL for the last 23 years, and I cherish doing this every summer. It was a momentous term in the United States Supreme Court. I've been teaching constitutional law for 42 years and cannot think of any term like it during this time. The closest analog that I can think of is to 1937, when the Supreme Court overruled 40 years of precedent and dramatically changed constitutional law. Last July, we talked about the death of Ruth Bader Ginsburg in September of 2020 and the confirmation of Amy Coney Barrett in October of 2020. I made 2 predictions on this program last summer. One is we would see a lot more 6-3 decisions. There are 6 conservative justices appointed by Republican presidents, 3 liberal justices appointed by Democratic presidents. I also said we'd see fewer 5-4 decisions with the liberal justices in the majority. Simple arithmetic explains this. Now for the 3 liberals to get a majority, they get 2 votes, not just 1 among the conservatives. Both of these predictions were not this term, which was the first full year with Amy Coney Barrett on the court. The Supreme Court decided 60 cases with signed opinions after briefing and oral arguments. It's a bit more than the 54 a year ago or the 53 the year before that. There were 19 6-3 decisions and there were 9 5-4 decisions. Only 29% of the cases were unanimous, the smallest in recent memory. The 2 justices most often in the majority were Chief Justice John Roberts and Justice Brett Kavanaugh. They were in the majority 95% of the time. The justice least often in the majority was Justice Sonia Sotomayor. She was in the majority only 58% of the time. I worry, though, that these dry statistics don't really tell the tale of the term. I'd identify 3 themes that I think you'll see borne out as we discuss specific cases. First, the conservative position prevailed in almost every major case this term. On the front page of the New York Times on July 2nd was statistical analysis that concluded that this was the most conservative term since 1931. If you think about the issues that most define who's liberal and conservative in our society: abortion, gun rights, separation of church and state. In each of these areas, there were major cases and the conservative position prevailed. Second, originalism triumphed this term. Originalism, the view that the meaning of a constitutional provision is fixed when it's adopted and be changed only by amendment. It was a theory developed, especially in the 1970s and 80s, as a way of criticizing Warren Court decisions, and particularly criticizing Roe versus Wade. When Robert Borick was considered in 1987 for the Supreme Court, his originalist views were a basis for a decisive rejection by the United States Senate. But as we talk today about the gun cases, the separation of church-state cases, and so many others, the Supreme Court took an explicitly originalist position. And third, precedents seem to matter little this term. We all know that the court overruled Roe versus Wade. The court also overruled Lemon versus Kurtzman, the 1971 decision that had defined the walls separating church and state. The court abandoned precedent in other areas as well. Two things to conclude this overview. First, how did we get here? Between 1960 and 2020, there were 32 years with a Republican president and 28 years with a Democratic president, almost even. But between 1960 and 2020, Republican presidents picked 15 justices, whereas Democratic presidents picked only 8 justices. Or to put this another way, we all know that President Donald Trump picked 3 justices in 4 years. But the prior 3 Democratic presidents, Jimmy Carter, Bill Clinton, and Barack Obama, so to combine 20 years in the White House, in those 20 years, they picked only 4 justices. Second, how long is this likely to last? Clarence Thomas is the oldest of the justices. He turned 74 in June. Samuel Alito turned 72 in April. John Roberts is 67. Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett are all still in their 50s. I've long thought that the best predictor of a long lifespan is being confirmed for a seat on the United States Supreme Court. John Paul Stevens retired at age 90. Ruth Bader Ginsburg died at age 87. So it's easy to imagine 5 or 6 of these conservative justices being together another decade or 2.
Thank you, Erwin. And I want to turn now to Greg to give us, again, a 5-minute overview. And maybe, Greg, and it's such a treat to have you here, a little bit, if you would, through the lens of a court that started the term with a 37-ish% approval rating, the lowest since Gallup started polling. Now, in the last few weeks, that approval rating is down in the 20s. So there is, I think, in addition to the momentous cases Erwin just talked about, a new sense of real friction between the court and the American public. And that actually is making its way into the cases where the justices are talking about public confidence. So I wonder if you can both respond to what Erwin just said, and also, just in the interest of setting the table, contextualize this with respect to questions about that legitimacy of the court, which is, I think, singularly challenging right now.
Sure, and I'll do that, Dahlia, and thanks so much for having me here today. It's truly an honor, and it's hard to follow Dean Chemerinsky's summary, and I actually agree with a lot of it. I mean, this was a truly historic term, one with major wins for the conservatives. What may be the liberals' worst nightmare, but frankly, one that conservatives had been hoping for some time. And I think, really going into the term, the question was not so much which direction the court was headed in, but how fast it was going. And, we had some indications last year in terms of the cases that the court had accepted with respect to abortion and guns, that this was a court that was sort of gearing up. And I think, the term's results certainly bear that out, that this is a court that is, not going to wait on particular areas and that is prepared to move boldly. I think in looking at the term, the biggest movement is between the Chief Justice and the shift to the right and Justice Kavanaugh. 2 terms ago, the Chief Justice alone had control over how fast the court would go and uniquely control the brakes. And now he doesn't, because there's 5 conservatives to his right. And it's really, Justice Kavanaugh where you see the shift. And the Chief and Justice Kavanaugh voted together 100% of the time, which is remarkable in terms of the results. And we're together in 95% majority. 95% of the time they were together, they were in the majority. But yet, obviously, in Dobbs, they weren't together in terms of the rationale and how far the court would go. And that would make all the difference there, and is the most notable decision of the term. And that shows, I think, really where the court has shifted. But together still, they can impose important limits on the court and how far they will go. And Justice Kavanaugh made that clear in his separate opinions in the Dobbs case and the Bruen case, which obviously were with the majority, but yet posed real limits. I think what's different is not that we've got 6 justices appointed by Republican presidents, but that we have true, for the first time, 5 truly committed constitutionalists and originalists. And so I agree with Dean Chemerinsky on that. And Dobbs and Bruen, the gun case, illustrate more vividly than anything else. And really, this term was sort of a triumph for originalism and constitutionalism. And in that respect, it shows that Justice Scalia's influence on the court is still, paying dividends for the conservatives, and that his presence is still real. I disagree just a little bit with the dean in terms of how monolithically conservative this court is. It is, and it was in the most important cases, and that's how this term will be defined. But I still think this is a court still in flux with a fair amount of crossover in the less contentious cases and movement, including among the conservative justices. But there were several decisions which reached results that I think could be described as more liberal than conservative. On the last day of the term, we had the Remain in Mexico case, the Biden versus Texas. The liberals prevailed in one of the COVID vaccine cases. There was criminal cases in which they were in the majority, and this was a bad term for employers on arbitration cases. Those are all far less important than the major cases we're going to talk about today. But it still shows a dynamic court, and one that is still in flux. And I think we'll see more with that with the new justice next term. In terms of your question and public opinion, I think it sort of raises the maxim from the conservative perspective that you have to be careful what you wish for. This was a dramatic term in terms of the results. It is, as the Chief Justice remarked in his Dobbs concurrence, Dobbs itself is a serious jolt to the legal system, and that'll have repercussions. That'll have repercussions that we can't forecast today. We've seen a dip in the opinion polls for the Supreme Court. It's unclear to me how much that is driven by the nature of the polling, and certainly, the loudest voices right now are ones that disagree with the court. But the fact is that we have seen the public opinion go down, and that's tough for the court. The court, unlike other branches of government, doesn't have press secretaries. They can't send someone out there to spin the narrative one way or the other, and the court uniquely depends on public confidence for its legitimacy. And so that is an important factor to consider. And really, more than anything else, the fencing around the court today is a perfect metaphor for where the court is. And that's not a great place for the court, no matter how much some on the right may welcome the decisions. But this is a tricky position for the court, and one that we'll no doubt see play out in years to come.
Thank you so much, Greg. I want to turn to Amy for just some a little bit of an overview and a sort of thoughts on the term, and maybe I would ask you to pull a little bit, if you would, on both Erwin and Greg's velocity theme, because one of the questions is, I'm reminded of Professor Leah Littman, who calls this the YOLO, you only live once, court, because it just seems to be pressing on getting things done quickly. And I think it's really striking that we've been at this for 20 minutes and haven't said the word leak yet. We had the most consequential leak in Supreme Court history by my lights, which I think connects to some of what Greg was talking about in terms not just of public confidence in the court, that's a piece of it, but the justices' confidence in one another and what's going on in the building. So I wonder if you would bounce some of those themes around in your opening.
Sure. This was and a thank you to the National Constitution Center and ADL for inviting me. I'm really honored to be here. This was, as a reporter, a really fascinating term to cover. The Supreme Court was back in session in the courtroom, but the courtroom was closed to the public. And so this is also, I think, a little bit of a metaphor, much like the fences. The the oral arguments were live streamed, but only a small group of reporters, clerks, and lawyers were actually allowed in the courtroom when the justices were arguing some of these incredibly consequential cases. And so, I've actually written about how few people get into the courtroom for oral argument, even at the best of times when the court is fully open. But that also seems like a little bit of a metaphor in the sense that the justices were, for the most part, not hiding, but operating behind closed doors. And then when it came time for them to issue their opinions in some of these truly historic cases, the justices were not on the bench reading their opinions the way that they would in non-COVID times. Someone at the Supreme Court pressed a button and the opinions appeared on the court's website. So we didn't have the summaries of the oral arguments from the justices who wrote the decision, nor did we have the dissents, which are sometimes read from the bench, and which I think we all would have expected to come in some of the cases that were issued this term. And so a lot of the fighting was behind closed doors. The leak, we still do not know who leaked it or why. There were also disputes about whether or not Justice Sotomayor asked Justice Gorsuch to wear a mask. But as someone who covered the court, I do think that much of the term, unlike in past terms when you had someone like Justice Kennedy or Justice O'Connor, and there were real questions about which way a decision would go, there was very little doubt in most of these historic cases about which way the court was going to go. The question really was, much as Leah Littman puts it, like, how far were they going to go? Were they going to issue a ruling that really moved the court to the right, or were they going to issue the more incremental ruling that someone like the Chief Justice might have issued?
And Fred, do you have just an opening framing thought for us on these big themes of how far, how fast, how much to worry about what the public thinks, and how long does this go on? Just for a brief minute.
Just for a brief minute, it's a lot to cover, but you think about basic political theory. Power comes from above, legitimacy comes from below, and power and legitimacy could be out of whack for little periods of time. That's the nature of a complex society, but they can't stay out of whack forever. And it's not yet clear what the relationship is right now between the court and the public, but the public opinion polls tell you something. And I think those are going to raise questions that we're all going to continue to follow. Greg made an important point when he said it's more about originalism among the conservative justices and the party of the president who appointed them. On the other hand, we are living in a time where it's almost a given now that presidents of one party appoint one kind of justice, another party, the other party, a different kind of justice. You go back to Roe against Wade, where you've got a Republican appointed justice who writes Roe against Wade. You've got a Democratic appointed justice who's in one of the dissenters. And that was just a given at the time. So I think now it feels much more partisan in that way. And that is a major concern for the court to be seen that way. I know justices, all federal judges, bristle at being referred to as democratically appointed judges, Republican appointed judges. Think of the Chief Justice saying, there are no Obama judges, there are no Trump judges, there are only federal judges doing their level best. All well and good for him to say that. I'm not sure that's how it lands with the public right now. And I think that does real damage to the legitimacy of the Supreme Court and of the federal court system.
We're going to turn now to specific doctrine areas, and just with a note that there's just no possible way we can cover everything. So we're going to try to get to the big issues. And as I noted earlier, put questions in the chat. And the first area we want to explore, Erwin mentioned, there's been a sort of sea change on questions of religious liberty, the wall separating church and state. And in big ways, I think that we have seen not just the erosion, as Erwin says, of the Lemon Test, but real questions about where we're going to and how we're going to recalibrate tests that have kind of stood for decades. So I want to start by asking Fred to talk about one of the religion cases that probably took up the most oxygen in terms of the drama surrounding it. Fred, can you quickly walk us through Kennedy versus Bremerton?
Bremerton School District case starts on the 50-yard line. High school football coach who after games prays at the 50-yard line and has students who are joining him. That much is undisputed. The school district takes a dim view of this and they ask him to stop doing it. He says, this is who I am, this is what I'm about. And so he continues to do it. And they put him on leave because of that. He claims that's a violation of his religious freedom rights, his free exercise rights, as well as his free expression rights. The school system obviously was concerned about Establishment Clause issues. That's why they took the action that they did. The court sides with the plaintiff here, not with the school district, by a vote of 6-3. This is in keeping with Erwin's theme about the 6-3 divide. Justice Gorsuch writes the opinion for the majority of the court. And to a certain extent, the difference between Justice Gorsuch's majority, Justice Sotomayor's dissent, joined by Justice Breyer and Kagan, it's almost as if they're not disagreeing, they're sort of talking past each other. Justice Gorsuch is framing this very much as a free expression issue and asking, is there a discrimination against religious speech, as it were, and that you can't do that kind of behavior. That's what the school district is doing, is discriminating against a certain kind of speech. Justice Sotomayor is saying that's giving short shrift to the Establishment Clause. If there is a distinction to be made with religious speech, you almost imagine Justice Sotomayor saying, I didn't make this up, the Establishment Clause did. So there's a different lens that Justice Gorsuch and the 5 other conservative justices have looking through it and view this in that way. There's also a factual difference as the way the two sides seem to see this. The majority sees this as a voluntary exercise of some students joined in the prayer and some students didn't. Justice Sotomayor sees this as fully pregnant with coercion. She looks to see, is there coercion here? And there are echoes of the Lemon against Kurtzman test. So another theme that Erwin mentioned at the beginning of courts being, opinions being overturned. It's interesting here what Justice Gorsuch does. He doesn't exactly overrule Lemon against Kurtzman. He observes that Lemon against Kurtzman has been essentially overruled. It's almost as if we don't know when it happened. It was either too early or too late, but now it's happened. And Justice Sotomayor picks up on that in her dissent and says Lemon against Kurtzman should still be the law. The court is giving short shrift to the Establishment Clause by its holding.
And maybe just saying really pointedly what Fred just said, sort of implicitly, which is this is an astonishing dissent by Justice Sotomayor because it contains photos, because we're actually having a factual dispute about what happened in ways that, at least for me, raised red flags about truth and shared truth in Supreme Court debates and doctrine. Greg, I had said that while Kennedy was the big ticket drama case, Carson actually may be the more consequential case. So can you walk us through the other really, I think, ground shifting case, Carson versus Macon?
Sure, absolutely. I mean, I think this may have been one of the least surprising results of the term, given the court's doctrinal development in this area of law. A few years ago, in a case called Trinity Lutheran, the court invalidated a Missouri program that offered aid to nonprofit organizations, but refused to allow aid to a child learning center run by a church that wanted to use it to repave a playground, held that that violated the anti-discrimination component protected by the religion clauses. Last term in the Espinoza case, the court invalidated a Montana provision of the Montana Constitution that prevented religious schools from participating in a tax credit program for those who provided tuition assistance to private schools. And so this case comes along and it involved a Maine law that allowed parents who lived in remote areas in which the school didn't actually have a public secondary school available to obtain tuition assistance from the state to send their kids to another school, but had barred the use of tuition assistance for religious education. And the court in this case held that that prohibition violated the religion clauses as well, and that if a state is going to offer tuition assistance to parents generally, that it can exclude parents who want to send their kids to religious schools. That provoked a dissent by Justice Breyer, joined by Justices Sotomayor and Kagan, which really focused on the doctrine of what had been known as the play in the joints between the Establishment Clause and the Free Exercise Clause, and said that the court's decision in this case had really for the first time, moved the Constitution from a situation in which states could or may provide tuition assistance to religious schools in this context where funds are made generally available to parents who send their kids to secular schools, to a situation in which states must provide such assistance, a result that the dissenters believed drew into conflict with the Establishment Clause itself.
And Erwin, I wonder if you can now pick up where we left off with the third religious liberty case we want to talk about, one that probably got a little bit less oxygen, but seemingly I think is of a piece with some of the big themes we've already touched on.
Short-lived for City of Boston, I think, is the least important and the least surprising of these three cases. At Boston City Hall, there are some flagpoles. And for one of them, the city will allow private groups to raise a flag. Between 2005 and 2017, 284 times private groups had asked to have a flag raised. 284 times the city raised the flag. Then Harold Shurtleff came and said, I want you to raise a flag that's just a cross. The city said, we can't do that because we're concerned about the Establishment Clause. Shurtleff sued the city of Boston. The federal district court and the United States Court of Appeals for the First Circuit ruled against Shurtleff. They said a flagpole is a place for government speech. When the government is the speaker, its speech can't be challenged as violating the free speech clause of the First Amendment. And so the issue that was before the Supreme Court was, is this flagpole a place of government speech, or is this a forum for private speech that's been created by the government? The Supreme Court unanimously reversed the lower courts. Justice Breyer wrote for the court, and he said, here the city has created a forum for private speech. He stressed the city having approved 284 out of 284 requests. And therefore, he said, it violated the free speech clause of the First Amendment to exclude this flag. He said it wouldn't be an establishment of religion to raise the flag because given that the city was raising all of the flags, no one would perceive this as the government endorsing religion. Justice Gorsuch wrote a concurring opinion, which he said, the problem here is the test from Lemon versus Kurtzman. This court should overrule Lemon versus Kurtzman. This came down on May 2nd. Interestingly, as Fred pointed out, on June 27th, Justice Gorsuch, in a majority opinion, said that Lemon has already been overruled. Dahlia, I agree with you that this case is, together with the other two, it shows a court that gives no real weight to the Establishment Clause of the First Amendment. That was the point of Justice Breyer's dissent in Carson versus Macon. It was the point of Justice Sotomayor's dissent in Kennedy versus Bremerton School. It was enormous weight to free exercise of religion and to free speech, but not to the Establishment Clause at all. After all, it was the Establishment Clause that the Supreme Court always said embodied what Thomas Jefferson spoke of, the wall separating church and state. And I think the direction of these cases shows an enormous change that's happening with regard to prayer in schools. Since the early 1960s, the Supreme Court, without exception, had found that prayer in public schools violates the Establishment Clause. Now it seems that before the school day, or at recess, or lunch, or after school, teachers can engage in prayer in the classroom, and if students want to join them, there's no violation of the Establishment Clause. The Supreme Court has now said, as Greg pointed out, whenever the government funds private secular schools, it is constitutionally required to fund religious schools. In many places across the country, there are charter schools where public school systems fund schools operated by private entities. In California, there's a law that says that they must be secular. I expect religious groups will now come forward and say that violates the Establishment Clause. Or think of all the government programs that have existed that fund secular activity, but won't fund religious activity. I think now there's an argument all of that's unconstitutional. The court has obliterated any notion of a wall separating church and state.
We've reached the part of the program that I think a lot of folks are tuning in to hear, which is reproductive freedom and reproductive rights. The court heard actually two cases, Whole Women's Health versus Jackson. That was the SB 8 challenge in Texas. And then, of course, at the very end of the term, Dobbs versus Jackson Women's Health. Amy, I'm going to turn to you to try to kind of get us through understanding what happened in September, what happened midwinter, what happened in terms of Dobbs, and where we are right now, and try to leave ample time for other folks on the panel to jump in.
Excellent. I will try to do it as succinctly as possible. I'm going to start with Whole Women's Health versus Jackson, the SBA case, because I feel like how the court dealt with it really gave us a roadmap for how the court was likely to deal with Dobbs further on down the line. So SB8 is a Texas law that prohibits abortions once doctors can detect what's called cardiac activity, which usually occurs around the 6th week of pregnancy. So this law conflicted directly with the court's decisions in Roe versus Wade and Planned Parenthood versus Casey, which said that the Constitution protects the right to have an abortion before the fetus can survive outside the womb, which is usually around 23 or 24 weeks. But the law had a unique enforcement mechanism that deputizes private individuals to enforce the law against anyone who aids or abets or provides an abortion. So on September 1st, the justices allowed the law to go into effect. And the first challenge came to the court on what the emergency docket, also sometimes called the shadow docket. So the court decides this just based on an initial set of briefing without full briefing or oral argument. And the justices divided 5-4. The majority said that because of the enforcement mechanism, it wasn't clear whether the provider's lawsuit could go forward against the state officials who were named as defendants in the complaint. The Chief Justice, John Roberts, dissented. He was joined by the liberal justices. He said that he would put the law on hold while we figured out whether or not this enforcement mechanism allows a state to avoid responsibility for its laws. The case came back to the Supreme Court once again through the shadow docket in late October with regard to the private enforcement mechanism, whether or not the provider's lawsuit could go forward. The court once again divided, ruled that the lawsuit could not continue against state court judges and clerks. The Chief Justice and the liberals agreed with the majority, except for Justice Thomas, that the lawsuit could go forward against state licensing officials, although that turned out to be a fairly hollow victory for the providers because when the case went back, they sent the question to the Texas Supreme Court, which said that those officials also lacked the power to enforce the law. That is, there's no one that they can sue before the law goes into effect. So then on December 1st, the justices heard oral argument in Dobbs versus Jackson Women's Health Organization. That was a challenge to a Mississippi law that bans almost all abortions after the 15th week of pregnancy. So again, conflicted with Roe and Casey. There seemed very little doubt from the point at which the justices announced that they were going to take up this case that they were likely to uphold the Mississippi law. The question was, are they going to overrule Roe and Casey as the state asked it to do once the justices had granted review, or are they going to stop short of formally overruling Roe and Casey, but still uphold the law? We had the draft opinion leak in May, and then it became official at the end of June. 5 justices and an opinion by Justice Alito voted to overrule Roe and Casey. They said, and this is picking up on Erwin's theme about originalism, there's nothing in the Constitution about abortion, to the extent that the Supreme Court has sometimes recognized fundamental rights that are not specifically mentioned in the Constitution. There is not the kind of deep-rooted history of abortion that would allow abortion to be recognized as a constitutional right. And then they acknowledged the decision, that this is the overruling precedent, acknowledged the concept of stare decisis, the idea that the court should not overrule its prior precedent unless there's a good reason to do so. But they said there is a good reason to do so here because Roe was egregiously wrong. The Chief Justice, John Roberts, flew solo on this one. He agreed with the court that the Mississippi law should stand, but he would not have formally overruled Roe and Casey. One other point is that the Alito opinion insisted that this decision would not affect other fundamental rights that are not included in the Constitution, like the right to same-sex marriage, the right to same-sex intimacy, the right to contraception, because he said, in essence, those are different. Abortion involves the purposeful termination of life. Justice Thomas wrote a separate concurring opinion in which he suggested that those precedents upholding those rights are very much in play and that the court should reconsider them soon.
And Greg, can you take a couple of minutes and respond, and maybe also specifically, if you would, tease out the question that is left lingering, that Amy left lingering, which is what are the implications for Obergefell, marriage equality, Lawrence versus Texas, sexual intimacy between same-sex partner, and even questions about Griswold versus Connecticut and the right to contraception in the wake of this seemingly pointed dispute between Justices Alito and Thomas on what is now on the table.
Sure, absolutely. I pick up first with Amy's point that going into the term, there wasn't much question about whether or not the court would uphold the Mississippi ban, but the question was whether it would actually go further and overturn Roe itself. And, you know, I think looking at the way the case is litigated is pretty interesting. Initially, when Mississippi asked the court to take the case, it just focused on the validity of the 15-week ban. But then after they granted, Mississippi went all in and asked the court to overrule Roe. I think what's interesting here is that the plaintiffs and the government made a strategic gamble that it was better to push the court to the brink on Roe instead of actually sort of seeking some kind of middle ground and arguing that there was a way to uphold the ban without overturning Roe, which ultimately is where the chief came out. When they were asked about that at oral argument, they explicitly said that no, there was no sort of middle option. You either had to overrule Roe or not. And, you know, ultimately that's what the court did. But I do think that in approaching the case that way, it made it significantly harder for the chief to gain any momentum with his efforts, essentially to provide that kind of middle ground of upholding the Mississippi law and leaving some version of Roe in place. You know, one thing I think is interesting about the decision, which obviously is hugely consequential and momentous in so many ways, is that, you know, the notion that this decision is going to eliminate litigation over abortion or take abortion out of the Supreme Court, I think is, you know, not going to pan out. This decision is going to, you know, lead to enormous new litigation over Roe, you know, restrictions on travel, exceptions to abortion, you know, any number of other laws. So abortion is not going away. It's not going out of the Supreme Court. You know, there is going to be much more activity in the states in the democratic process. But the notion that we can now go on our lives and not worry about abortion in the Supreme Court, I don't think that's going to play out that way. You know, in terms of the other rights, I actually think it's pretty clear today that the court is not going to upset or overturn those rights. Justice Alito indicated that in his opinion for the court. You know, maybe more importantly, Justice Kavanaugh drew a red line in his concurrence that this decision did not threaten gay marriage, interracial marriage, contraceptive, other, you know, the other list of decisions that Justice Thomas targeted in his dissenting opinion. And you can debate whether or not that's going to hold, but I think it, you know, right now, Justice Kennedy is, you know, at the center of how far the court will go. And this decision shows that more than anything. And he made clear in his concurrent opinion that he was not going anywhere near there. So I think, you know, as a practical matter, I think that ends debate on it. As a doctrinal matter, you know, obviously there are, you know, there's at least one and probably more who would revisit those precedents.
Greg just won the first Freudian slip of the panel award because you said Justice Kennedy instead of Kavanaugh, but made perfect sense. And maybe I would note one quick thing, which is usually it's me who does it, Greg, that when Erwin mentioned at the beginning that this is no longer the John Roberts court, that in some sense he is no longer the decider. One of the interesting things linking up what Amy and Greg just said is that the Chief Justice, who has sided with the liberals, at least in some of these areas, frequently does it either because he doesn't like the shadow docket, he doesn't like doing major doctrinal work on the shadow docket, on the emergency docket, and because I think he really does worry about those jolts that Erwin and Greg talked about. That is the place where he peels off. I don't think anyone should make the mistake of thinking that John Roberts was a fan of Roe v. Wade. Let's turn to guns, if we may, which was another incredibly hot button issue that the court just took square on and hit the gas. What do you got for us, Fred, on Bruen? You're muted.
Certainly was a case of hitting the gas. Indeed, the New York State Rifle and Pistol Association against Bruen was the most significant gun rights case to come before the court in a decade, since DC against Heller in 2008, and then the state version, McDonald against City of Chicago in 2010, which first formally recognized an individual right to bear arms under the Second Amendment. At issue was New York State's century-old law prohibiting the carrying of a shotgun outside the home without a license and denying licenses to citizens who cannot show proper cause to carry a firearm. The majority of the court, 6 justices, Justice Thomas writing the majority opinion, find that to be unconstitutional under the Second Amendment and under Heller. The Second and 14th Amendments were found in Heller and in McDonald to protect an individual's right to carry a handgun for self-defense. The question then is, what about outside the home? Now, in 43 states, the government issues licenses to carry based on certain objective criteria, what we could call shall issue laws, where if those criteria are satisfied, the permit shall issue. New York was one of those 6 states that had a may issue statute. That is a distinction that is highlighted by Justice Kavanaugh in his concurrence, saying that those other shall issue laws are certainly still good and those restrictions are still permissible. But Justice Thomas says in this case, he's focusing on the may issue in New York and uses this as the predicate for rejecting the approach under Heller that most courts of appeals had used. Most courts of appeals had used a 2-step analysis to interpret the Second Amendment. Step 1 is whether the government can demonstrate that the regulation for gun rights is consistent with historical tradition of firearm regulation. If a firearm regulation is consistent, then the analysis stops there. But if the historical evidence is inconclusive or suggests the regulated activity is not categorically unprotected, then we go to step 2, which asks how close did this law, this regulation, affect the core Second Amendment right? If it was core right that was burdened, then the court would use strict scrutiny. Otherwise, it would use intermediate scrutiny. Justice Thomas, for the majority of the 6 conservative justices, rejects that 2-step approach and says it's only a 1-step test under Heller, and that is a test of whether or not the right is deeply rooted in history. The test is what is deeply rooted in history, and he says the New York statute, century old or otherwise, fails the historical test. It fails the historical test using, he looks to evidence from the colonial period, looks to evidence from the pre and during and immediate past Civil War period, and in fact, provocatively looks at evidence of the ways in which the right to bear arms was used by newly freed slaves to defend themselves following the Civil War. Overall, Justice Thomas found that the burden to show that the American tradition justified a proper cause requirement had not been carried by the state of New York. Justice Breyer writes a dissent joined by Justices Sotomayor and Kagan, and in an interesting way, yet again, as we saw earlier, it's not so much that they disagree, although they certainly do, but they seem to be talking about different things. They seem to be going past each other again. Justice Breyer starts his opinion not with a discussion of history, but with a ringing statement about gun violence in the present, and looks at statistics about the immediate past up to and including the present year of gun violence. Justice Breyer says, only by ignoring an abundance of historical evidence supporting regulations restricting the public carriage of firearms can the court conclude that New York's law is not consistent with the nation's historical tradition of firearm regulation. Justice Breyer also raises questions as to the whole methodology of the history test. And he says judges are, after all, not historians, and that we're going to wind up getting caught up in judges doing what he calls law office history, that this is not what we're best at. And he cites scholars who, after the Heller case, questioned whether the court got the history right after Heller. So Justice Breyer and the dissenters would have said that a different approach, an approach that takes a much heavier weight to the government interest and the government right to regulate in this area and interest in regulating in this area should play a larger role. He also says that in other areas, like the First Amendment, strict scrutiny analysis is used. There's no reason why we shouldn't be using that kind of an analysis in the Second Amendment area rather than a history test. Last word quickly on this is that Justice Alito in his concurrence goes directly after Justice Breyer and his reliance on history. So to the extent that it is not clear that Breyer had a different methodology, Justice Alito wants to make very clear that he endorses not only the result of the majority, but the historical test approach of the majority, and goes foursquare at Justice Breyer, taking a different view, which many of us will associate with Justice Breyer's not only jurisprudence, but with his scholarly writing as well and his theory of active liberty.
Greg, do you want to give us a quick minute on Bruen?
Sure. I mean, I think this case underscores how big this term was, because if we just had this decision, it would be a blockbuster term. It's sort of a contradiction here, because as a practical matter, the decision is not hugely specific in the narrow sense that there are only 6 states that have these may issue or may carry regulations. But as a doctrinal matter, this decision is hugely important. I mean, it sort of, underscores the originalism theme that we've talked about. It invigorates this constitutional right that the court had recognized in Heller more than a decade ago, and nobody really knew what to deal with it. And, significantly strengthens the analysis that courts have to apply in determining whether gun regulations are constitutional. This case also underscores the themes we've been talking about in terms of the limits that the Chief and Kavanaugh can still impose in the court. Justice Kavanaugh's concurrence in this case, as in Dobbs, imposes, draws lines and imposes limits. He makes clear that shall issue laws and restrictions, mental health counts, restrictions and the like, are constitutional in his views. And those are the laws that we find in 43 states. And he underscores what the court said in Heller, which is that a variety of gun regulations, are constitutional. But of course, it remains to be seen how that'll all play out in the wake of this decision.
And Erwin, a closing thought on Bruen?
I expected the result that the Supreme Court would strike down the New York statute. I didn't, though, expect how far the court would go in protecting gun rights. As Fred says, for all other fundamental rights in the Constitution, free speech, free exercise of religion, privacy, the government can act if it meets strict scrutiny, if what it's doing is necessary to achieve a compelling purpose. But here the court says it doesn't matter if the government meets strict scrutiny. Gun regulation is allowed only if it's a kind that was historically permitted. Thomas says the Second Amendment is the very product of interest balancing by the people, and it surely elevates above all other interests the right of law-abiding citizens to use arms for self-defense. The court's never said that the Constitution elevates free speech or free exercise of religion or privacy above all other interests. This uses originalism in a new way. Up until now, originalism is always used by conservatives to define whether a right exists. Now the court is saying also originalism determines when the government can act, and only if it's a type of gun regulation that existed in 1791 and maybe 1868 is it allowed today. It is stunning how the court is limiting the ability of the government to regulate guns.
And there's a little internecine fighting in the majority and in the more in the Alito concurrence and the dissent by Justice Breyer about how relevant those gun statistics and gun deaths, catastrophic gun deaths, have any bearing on this case. Amy, can you walk us through content moderation?
This is another case that came to the Supreme Court on the shadow docket. It's a challenge to a First Amendment challenge to a Texas law that bars large, and by large, I mean 50 million users, social media platforms like Facebook and Twitter from removing posts based on the viewpoints they express. There was a sense expressed, for example, by the Texas governor that these companies were discriminating against conservative viewpoints. So they came to the challenge came to the court on the shadow docket, and by a vote of 5-4, the Supreme Court blocked Texas from enforcing the law while litigation over its constitutionality continues. The lineup was unusual. Justice Kavanaugh and the Chief Justice voted together, along with Justice Barrett, Justice Breyer, and Justice Sotomayor, to put the law on hold. There were 4 dissenters: Thomas, Alito, Gorsuch, and Kagan. Because the case came on the shadow docket, we don't know what the majority's reasoning was. Justice Alito wrote a dissent that Justice Thomas and Justice Gorsuch joined, in which he said that to put the law on hold, the technology groups challenging the law would need to show that they were likely to prevail on the merits. But because these are such novel questions, it's not clear that they would be able to do so. Some of you may be thinking, why is Justice Kagan, who we think of as a liberal, in the dissent? She did not join Justice Alito's dissent, but she noted that she would have denied the technology group's application. Dahlia's colleague, Mark Joseph Stern from Slate, has suggested that this was a vote based on principle rather than on the substance. Justice Kagan, like the Chief Justice, has said that perhaps the shadow docket is not the best place to resolve these big issues on the merits. Florida has a very similar law. The 11th Circuit in late May blocked Florida from enforcing the law. Florida has signaled that it is going to file a petition for review. So this is a question that we could very well see at the court in the very near future.
And I wonder if any of our panelists has a concluding thought on this?
I thought the piece that was interesting to me in the Alito dissent, and as Amy said, there is the 3 of them dissenting, Justice Kagan dissents, but without an opinion, is a very heavy state rights emphasis, where he says that a preliminary injunction is already a sufficient interference with state sovereignty. One would have thought that a injunction based on enforcing a constitutional right could be framed as not just as an interference with state sovereignty, but as enforcing or protecting the federal Constitution. So the fact that Justice Alito took the time to use the shadow docket to write this opinion is something I think we should pay attention to.
And we're going to turn to voting rights, which is just so profoundly consequential for this term and going into next term. Amy, do you mind again doing the heavy lifting on the Wisconsin cases?
Sure. These are cases that really flew under the radar, including my radar, although I looked back when you asked me to introduce it and realized that I did cover it, but the court's order came down during the Ketanji Brown Jackson hearings. And so I don't think it got the attention that it deserved. And so I am also very curious to hear what Greg and Erwin have to say about it. This, like so many of the voting rights cases these days, stems from states' efforts to draw new maps in the wake of the 2020 census. And the procedural history is a little bit complicated. What I hope you need to know is that the Wisconsin Supreme Court adopted a redistricting plan for the state's legislature that had been submitted by the state's governor, who's a Democrat, Tony Evers. And the plan would have increased the number of majority Black districts in the state assembly from 6 to 7. And the state Supreme Court, in its decision, said there were good reasons to believe that this 7th district, majority Black district, is needed to satisfy the Federal Voting Rights Act. The Wisconsin legislature came to the Supreme Court, which threw out the state Supreme Court's ruling in an unsigned decision. The majority said that the Wisconsin Supreme Court could adopt the maps only if it thought that the Voting Rights Act required an additional majority Black district. And it said the state Supreme Court in this case had conceded that it wasn't sure about this question. So it sent the case back to the state court and said the majority said they didn't want to order additional briefing and oral argument, as they've done with some of the other cases that came to the court on the shadow docket this term, because they wanted to give the state court enough time to adopt new maps before the August 9th primary election. Justice Sotomayor dissented in an opinion joined by Justice Kagan. She said that usually we issue these kinds of summary rulings when there is a violation of settled law. But here the Supreme Court's just sending the case back because the state Supreme Court failed, she says, failed to comply with an obligation that under existing precedent is hazy at best. The justices also rejected at the same time a request from Wisconsin Republicans to throw out a state Supreme Court ruling adopting the governor's map for the state's federal congressional districts.
And Greg, do you have a quick thought on Wisconsin?
Yeah, I mean, I agree with Amy. The real fight in the case was about whether or not this was appropriate for summary adjudication. But I think, looking at this more broadly, I think this is really a case about race as much as voting rights. And, race was the one big issue that wasn't really teed up by the court this term. But, this term may be sort of a precursor of what's to come next term in terms of the court's focus on race. And this is an indication, which should not be surprising, that, at least the majority of the court is, uncomfortable, or at least red flags go up when the government is considering race and making decisions for whatever reasons.
Erwin?
I want to quickly tie this to another ruling on the shadow docket about elections, a case called Merrell versus Milligan from February 7th. What happened here was a 3-judge federal district court in Alabama held a 7-day hearing and 1,000 pages of briefing and found that the districting for the Alabama legislature, the congressional districts in Alabama, violated the Voting Rights Act. It was 2 Trump appointees and a Clinton appointee on this. The Supreme Court 5-4 stays this. It's the 5 most conservative justices, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. Roberts joins with the liberals, Breyer, Sotomayor, and Kagan. There's no opinion of the court. Justice Kavanaugh writes separately to say that the court's doing this because of the so-called Purcell principle that courts shouldn't get involved in elections soon before they occur. But this was in February. The Alabama primary wasn't until May. The general election wasn't until November. The practical reality is that an election map that a 3-judge court found to be racially discriminatory would be used for the next elections. This is going to make it very difficult to ever bring a challenge to districting, because inevitably districting occurs soon before the election, and the court has stepped in here. And so I think this does fit with the Wisconsin case, in that in each instance, the justices stopped lower court rulings. And it can't be ignored that in each instance, they were siding with the Republicans, with the Democratic appointees siding with what the Democrats wanted. I think this helps undermine the legitimacy of the court, is what we've been talking about.
And we're going to loop back when we talk about next term, because voting rights is certainly not going away, as Greg just said. But let's just take a few minutes to cover the immigration docket. It was a consequential term there as well. And Fred, I wonder if you can romp through Biden v. Texas.
A very quick romp through Biden v. Texas. Biden v. Texas involves the Trump administration Remain in Mexico policy. The formal name is the Migrant Protections Protocol, the MPP, which required asylum seekers to remain in Mexico while officials reviewed their case. The policy was litigated through the Trump administration, but before the court ever got to make the Supreme Court got to make a final decision on it, the Biden administration rescinded the rule. And then that rescission itself was challenged by the states of Texas and Missouri, both under immigration law and also under a technical issue of administrative law. The court, by a vote of 5-4, with the this is the other 5-4 configuration that we've seen now several times, the Chief Justice and Justice Kavanaugh joining the 3 liberal justices, Breyer, Sotomayor, and Kagan, wrote an opinion siding with the administration. Interestingly, Justice Barrett on the merits would have agreed with the administration. So it's actually 6-3 with respect to the administration's right to rescind this policy, but she would not have reached the case not being appropriate to hear at this time. And she would have had it remanded for reconsideration in light of another immigration case the court had decided. The majority opinion by the Chief Justice is based on the idea that the program did not violate the Immigration and Naturalization Act, which provides a discretionary choice. It says that the Secretary of Homeland Security may return the alien. May, the court says, clearly denotes discretion, and that the decision to rescind the regulation was an exercise of that discretion. Justice Alito writes a dissent joined by Justices Thomas and Gorsuch, in which he says that the government cannot simply release aliens into the country and hope that they will show up for hearings. He says that, in fact, Congress has given the agency two different alternatives, and that the agency may not take the alternative that they did. There's a flavor of this in Justice Alito, Thomas, and Gorsuch's view on administrative law that we see come up in the West Virginia case that we're not going to talk about today, but is an important issue that the court decided as well. It is the notion of the dissenters that the Department of Homeland Security must use either the option of, if an alien arrives on land from a foreign country that is contiguous to the states, returning the alien to that country, or releasing the individual on parole on a case-by-case basis, but not to rescind the regulation, which is what the court did. The majority view by the Chief Justice, it fits within the idea of a greater deference to the executive branch, particularly on issues of immigration. One of the arguments that the majority points out is that this right to the policy and the rescission of the policy both go directly to the policy, foreign relations between the United States and Mexico, a issue consigned to the executive branch.
That was superb, Fred. Amy, can you equally rompishly take us through the other two big immigration cases?
Sure. These two cases both involve are cases in which the government prevailed against the non-citizens in issues involving statutory interpretation, kind of the bread and butter of immigration law, but very important for the people who are affected. The first case I want to start with is a case called Johnson versus Artiago Martinez. There's a provision of federal law that governs the detention of non-citizens who've been ordered removed or deported from the United States. And it requires detention for the first 90 days after the removal order becomes final, and then allows for the longer detention of some non-citizens in particular cases. The non-citizen in this case was entered the United States without authorization from Mexico. He was ordered removed, but then detained. He raised what's called claims under withholding of removal. He argued that he would be persecuted or tortured if he were returned to Mexico. So he stayed in detention. These kinds of claims involving withholding of removal can take sometimes months or even years to resolve. So the question in his case was whether he was entitled to a bond hearing before an immigration judge after 6 months in detention. The lower court said yes. It said that the federal law was not clear, so courts should interpret it to require a bond hearing to avoid a violation of the Constitution. The Supreme Court's answer was no in a decision by Justice Sotomayor. She said there's nothing ambiguous about the law. There is no right to a bond hearing. The second case is similar to this, raised a similar issue, but it came to the court as a class action. And the court, by a vote of 6-3, ruled that another provision of federal immigration law prohibits class-wide injunctive relief. And for an immigrant who is held in detention, it's going to be very difficult to get your own lawyer to represent you to raise these kinds of questions. And so by prohibiting these class actions, it's going to make it harder for immigrants to raise these kinds of claims at all.
And I'll just very, very, very quickly summarize the COVID cases that Greg referenced. There were a pair of cases that were dramatically argued in the midst of the Omicron surge. We had bickering about who was wearing masks on the bench and whether lawyers were testing positive. Again, lots of drama for Supreme Court reporters. Essentially, two cases in NFIB versus Department of Labor. The court ruled that the OSHA administration had exceeded its power in issuing a vaccine or test mandate for large businesses. At the same time, in a parallel case in Biden versus Missouri, the justices, here by a vote of 5-4, granted the request that you could temporarily enforce a vaccine mandate for healthcare workers who are working at facilities that receive federal funding, maybe the very quick takeaway is that on these big questions of administrative actions, the major questions doctrine, which was invoked elsewhere this term, will be used, I think, to prevent the executive branch from using kind of old public health laws to address novel issues. But the takeaway, I think, from Biden versus Missouri is that the executive branch is still not without power to influence behavior so long as the spending clause is involved. And that was an incredibly short summary. We're going to do an equally short summary on Native American rights. Amy, this is you. And I'm sorry, you just seem to be getting tasked with all the very, very summary, short, skippy ones, but.
That's okay. That's, as a reporter, what I'm here to do. So I want to start back in 2020 when the Supreme Court issued its decision in a case called Mcgirt versus Oklahoma, which the court, by a vote of 5-4, with Justice Gorsuch writing for the majority, he was joined by the 4 then liberal justices, that land reserved for Native American tribes in northeastern Oklahoma remains a reservation for purposes of a federal law that gives the government exclusive power to prosecute major crimes committed by Native Americans in what's called in the statute Indian country. So the upshot of the Mcgirt decision in 2020 was that state and local governments could not prosecute Native Americans for these major crimes in almost half of Oklahoma. So fast forward to 2021, 2022, the case of Victor Castro Huerta, who was not a Native American, was convicted in state court of criminal child neglect involving his 5-year-old stepdaughter, who is a Native American. She was admitted to the hospital because she was severely malnourished, sentenced to 35 years in prison. After the Supreme Court decided the Mcgirt decision, a state appeals court vacated his conviction on the ground that the crime had occurred in Indian country. So it was applying Mcgirt to this scenario. Oklahoma came to the Supreme Court in this case and over 24 others. I think there were maybe 30 petitions for review in all, asking the Supreme Court. By that point, Justice Ruth Bader Ginsburg had passed away, had been replaced by Justice Amy Coney Barrett. Justice Ginsburg had been in the majority in Mcgirt, asking the Supreme Court to overrule Mcgirt. The Supreme Court took the Castro Huerta case. It said from the outset that it was not going to revisit Mcgirt. It agreed to decide only whether the state and local governments have the power to prosecute defendants who are not Native Americans, but commit crimes against Native Americans in Indian country. And the answer is yes. Justice Kavanaugh wrote for the court. He said the Supreme Court's precedent established that Indian country is part of a state's territory. States can prosecute there unless Congress preempts it. And then Justice Gorsuch now was in dissent, writing for himself and the 3 liberal justices. He said that the tribes keep their power unless Congress says otherwise. He used some pretty strong words. He said that truly a more ahistorical and mistaken statement of Indian law would be hard to fathom. And then the Supreme Court is looking ahead to next term, is going to hear another case involving the constitutionality of a law called the Indian Child Welfare Act, which was intended to protect against the separation of Native American families.
Amy, I'm tripling your salary. You're phenomenal. We're going to turn to the looking ahead portion of our conversation, and we're going to try to do that in such a way that we can get to some of your questions as well. So in terms of looking ahead to the next term, there is, as you've heard from a couple of our speakers, a fundamental shift in composition of the court, and it's widely said that one new justice creates an entire new court. I wonder, Fred, if you could just give us a thought on Ketanji Brown Jackson, on her influence on the court, and what her confirmation hearings this year taught us about what to expect.
It was Justice Byron White who famously said one new justice is a whole new court, by which he always said it meant it wasn't just that person has her or his own new relations with each of the justices, but he said all of the justices will have different relations with each other because a new person is now among the 9. Well, yes and no, I think. Yes, Justice Jackson clearly brings her own unique perspectives and history and story to the court. She is, of course, famously the first Black woman to sit on the court, but she is also the first former public defender to sit on the court, not the first person who's been a defense lawyer. Thurgood Marshall, of course, represented defendants on death row, but as a public defender, she brings that perspective. And as a former district court judge and appellate court judge like Justice Sotomayor, she brings all of those experiences, which many of her colleagues on the court do not have, having been a district court judge before. On the other hand, the best guess from what we can tell from her writings and her remarks, as well as opinions that she has authored, is that her jurisprudential approach will be roughly similar to that of Justice Breyer, for whom she clerked. We would expect to see some of the active liberty kind of approach that Justice Breyer advocated, and we've been talking about during this program today. And of course, that does not change the balance of the court. So we would expect to see many of the same 6-3 configurations, with Justice Jackson playing the role that Justice Breyer did. So in that case, less so. Also, one of the first places where we might have seen a major impact that she could bring to the court in the affirmative action case involving the admissions policies of Harvard and University of North Carolina in the fall. We won't hear her voice because she has recused herself as a former member of one of the boards at Harvard. It's been said that dissents are a letter to the future, the tradition going back at least as far as John Marshall Harlan the Elder and my hero Louis Brandeis. So who's to say what Justice Jackson's letters to the future will look like? The last piece I will say is that if you were to do in double harness her confirmation hearings and Justice Breyer's confirmation hearings, it's not that they took place in different decades, they took place on different planets. Justice Breyer was overwhelmingly approved. Justice Jackson very narrowly approved. It seems hard to dispute her merits for the court. It seems hard to dispute her adequate abilities and background for the court. So clearly something else was going on. Brings us back to where we started in terms of issues of legitimacy. We have an appointment process that has become, perhaps not surprisingly, part of a polarized climate that we have in Washington, and Ketanji Brown Jackson got fed directly into that. But she was confirmed, and she now is the newest justice of the Supreme Court.
Let's turn to some of the big cases next term. We've already flicked at a few, but based on even what we see docketed in the first few weeks of the term, it's going to be another monster year. Erwin, can you lead us off?
I agree with that characterization. Let me just pick a few examples. Affirmative action. In Bakke versus University of California Regents in 1978, in Grutter versus Bollinger in 2003, in Fisher versus Texas Austin in 2016, the Supreme Court said that college universities have a compelling interest in having a diverse student body. They can use race as one factor in admissions decisions to benefit minorities and enhance diversity. The Supreme Court has 2 cases on the docket as to whether to overrule those decisions. The students for fair admission versus University of North Carolina, students for fair admission versus Harvard College. So this is going to affect both public and private universities. My guess is that no one, conservative or liberal, has much doubt that the Supreme Court is likely to overrule those precedents. There's also the question of discrimination based on religious beliefs. It's 303 Creative versus Olenis. What's involved here is a woman who has a business in Colorado to design websites, but she refuses to design websites for same-sex weddings. Colorado law prohibits discrimination on the basis of sexual orientation by business. Does her free speech rights give her the right to discriminate in violation of state law? One more example, Moore versus Harper. This involves the so-called independent state legislature theory. In this instance, the North Carolina legislature engaged in districting that the North Carolina Supreme Court found violated the North Carolina Constitution. Is it only the legislature that gets to decide? Are state courts disempowered from enforcing state constitutions? Now, this is about congressional districts, but if this carries over, what would it mean in terms of the presidency? Could a legislature award the electors to a candidate that lost the popular vote in the state? The consequences of this are enormous if the court were to adopt the independent state legislature theory.
And Greg, do you have some thoughts on what's coming up next term?
those are the big ticket items I would have said as well. And, with a particular emphasis on the affirmative action cases. I mean, I think those cases will be as good of a barometer as anything in terms of whether or not the impact of this term will restrain or invigorate the court going forward. As was true in the abortion cases, there's sort of, two options for the court. One is to simply hold that the application of existing precedent was wrong, or to go ahead and overrule those cases. And, one way in which these cases may be different is that the Chief Justice here is someone who's been particularly outspoken in criticizing the use of race in college admissions. So remain to be seen how that plays out. But I think I agree with Erwin. This will be a momentous term as well, although I don't think anything will match what we just went through.